Okay, let's unpack this. Imagine yourself, maybe you're dreaming of a stunning villa overlooking those turquoise waters in Phuket. You're married to a Thai national, and this idea, buying property in this tropical paradise, it's really taken root. Sounds idyllic, doesn't it?
It really does.
But, well, as many find out, the legal side of things for property ownership in Thailand, especially if you're a foreigner, it can feel like a genuine maze.
Yeah, what's truly fascinating here is how often people just assume property ownership is, well, straightforward everywhere. But in Thailand, particularly when a foreign spouse is involved, it's far from it. Our mission today is really to dive deep into the legalities, the rules around property ownership when you're married to a Thai national. We want to pull out the key nuggets from our source material so you can be, truly well informed and hopefully avoid those surprising pitfalls.
Right. And we're drawing our insights today from a really comprehensive article. It's called Thai Spouse, Your House, Navigating Joint Property Ownership. And this resource comes from Ocean Worldwide. They're a luxury real estate agency actually based right there in Phuket, and they've been there since 2004.
Oh, wow, long time.
Yeah, their director, Sandra O'Neill, she spent years helping, literally thousands of families and property investors. Their focus is very much on that high-end luxury residential real estate in Phuket and Koh Samui, too.
You can really see that expertise in the article. We'll explore the why behind these unique rules, the nuances between different property types, and most importantly, how you can proactively protect your interests and steer clear of what the source quite bluntly calls those nasty surprises.
Nasty surprises. Definitely want to avoid those. So let's start right at the beginning, because this is where I think a lot of people hit their first major hurdle. Foreigners generally cannot own land directly in Thailand. Full stop. So for someone married to a Thai national, how does that fundamental restriction actually play out? What's the immediate impact?
Okay, so it means we begin with a really crucial point. Foreigners simply cannot own land outright, period. Now, when you're married to a Thai citizen, the land department, they require definitive proof, evidence, that any land being purchased was acquired using the Thai spouse's separate funds.
Separate funds, okay.
Yeah, and the key insight here isn't just that you can't own the land directly, but that any money you, the foreign spouse, contribute towards that land purchase. Well, legally, it's considered a gift to your Thai spouse.
A gift, really?
Yes, unless you make very specific separate legal arrangements, perhaps for the structures on that land, which we'll get into. But for the land itself, this often means a formal declaration is needed. The foreign spouse has to state officially that the money used was not marital property.
Wow, okay. That's a huge distinction. So even if I'm, say, providing all the cash for that dream beachfront plot in Phuket, I'm essentially signing away my legal claim to the land itself. Right there at the land department.
That's generally the effect of that declaration, yes.
Are there common mistakes people make with that? Or maybe types of evidence the land department asks for that might catch someone off guard?
Absolutely. It's a significant leap of faith if it's not structured correctly from the outset. The land title deed is almost always registered solely in the Thai spouse's name. That gives them full legal control.
Full control meaning?
Meaning the right to sell it, mortgage it, transfer it, basically without needing your direct consent or signature. Common mistakes. Oh, assuming a verbal agreement between spouses is enough. It isn't. Or just thinking transferring money into your spouse's account before the purchase is sufficient proof it was their money. The land department looks for a clear audit trail. Things like bank statements showing the funds came from the Thai spouse's own personal accounts, perhaps accounts held before the marriage, or maybe proof of an inheritance they received. Any ambiguity, and they'll likely flag it, causing delays or even blocking the registration. So yeah, this initial declaration, it's the first and arguably the most crucial hurdle.
Okay, hurdle number one, navigated, hopefully. With that fundamental restriction on land understood, this brings up another important question. What exactly does property mean in the eyes of Thai law when you're married? Why does that specific definition matter so much for people looking to buy?
It matters immensely. Because Thai law makes a very clear distinction that directly impacts ownership rights during the marriage and, crucially, if the marriage ends. We basically have two core legal terms you need to know. First, there's sin somros.
Sin somros.
Right. That refers to marital property. Generally, this includes pretty much all property acquired during the marriage. Think income earned by either spouse, benefits, or assets bought with jointly earned funds. It's typically considered owned jointly by both spouses.
Okay, jointly owned. Makes sense.
Then the other category is sin swan tua. That's personal property.
Sin swan tua.
Exactly. This covers assets owned by either spouse before the marriage, or, importantly, anything received specifically as a gift to one spouse, or an inheritance received by one spouse, even if it happens during the marriage. This type of property is considered individually owned, not joint.
And it sounds like the Civil and Commercial Code is the rulebook for all this. Our source specifically mentions Section 1469. What's the real significance or maybe the risk tied to that particular section?
Section 1469. Yes, it's absolutely critical. What it essentially says is that agreements made between spouses during the marriage about their property, well, they can be challenged later on.
Challenged by whom?
By either spouse, or sometimes even by third parties like creditors, especially if the agreement might negatively affect that third party's rights, or if it wasn't properly formalized. The real takeaway, the risk from Section 1469 is this. In Thailand, when you're dealing with major assets like real estate, informal, written agreements made during the marriage, if they aren't formally registered or made without proper legal advice, they're often viewed with skepticism by the courts. It's kind of a legal safety net for others, but it can absolutely become a tripwire for you if you're relying on just an informal chat or a simple note about who owns what, especially for something as big as a house or land.
Right. So it sounds like if you use funds that were originally your sin swan tua, say, money you had before marriage or maybe an inheritance you received, but you then use that money to, say, pay for a big renovation on the house bought during the marriage, things could get messy fast. How do you stop your personal property from accidentally blending into marital property?
That's precisely where meticulous documentation becomes, well, your absolute best friend. It's the tricky part, definitely, when sin swan tua gets mixed with sin somros. Your example is perfect, using personal inheritance funds to significantly upgrade or maintain a property that was technically purchased during the marriage.
Right.
Without clear, unambiguous documentation, and I mean receipts, detailed bank statements showing the money trail, maybe even a formal loan agreement between the spouses if appropriate. Without that proof, what you thought was clearly your separate personal contribution could potentially be reclassified by a court down the line as having become marital property sin someros. So it's not just about, keeping track of money. It's about proving the source and the intent behind those funds in a way that Thai law will actually recognize.
So if you're looking at those beautiful modern family villas down in Chalong, Phuket, understanding this difference, personal versus marital property, it isn't just legal jargon. It feels like it's the absolute first step to really knowing your rights and fundamentally protecting your investment.
Exactly right. Foundational knowledge.
Okay, with those distinctions clear, let's shift to the practical side. What's the actual process like? You're ready to buy. You go down to the land department to register a property in your Thai spouse's name. What happens?
Right. This is where that joint declaration process we mentioned earlier really comes into play. It's a physical requirement. Both spouses, you and your Thai spouse, must physically go together to the relevant land department office.
Both have to be there.
Yes. And there, the foreign spouse makes a formal written declaration. You state, on record, that the funds used for the property purchase are solely the personal assets, the sin swan tua of the Thai spouse. Now, this declaration isn't just a formality like ticking a box. It's absolutely crucial for the authorities. It's their mechanism to ensure that land isn't being indirectly acquired by a foreigner, which would bypass those core land ownership restrictions. It's a mandatory step, non-negotiable, really, to comply with Thai law for land purchase.
And what happens if the officials there at the land department suspect maybe the funds aren't truly the Thai spouse's personal money? Do they just take your word for it with the declaration, or are they actually digging into financial records?
Oh, they can definitely dig deeper. They often require what's called proof of personal funds. The land department has the authority, and frequently uses it, to ask for concrete evidence.
Like what kind of evidence?
Well, it could be bank statements showing the funds were already sitting in the Thai spouse's personal account for a reasonable time before the purchase transaction, not just transferred in yesterday,
Right.
Or it might be official documents proving an inheritance was received, or perhaps proof of a gift from their family. They are quite vigilant about making sure the money truly originated as the Thai spouse's personal funds, sin swan tua, and wasn't just, say, joint savings or money clearly transferred from the foreign spouse right before the purchase. This is exactly why talking to an experienced Thai lawyer beforehand about what specific documents will be needed and acceptable is not just wise, it's pretty essential to avoid frustrating delays or even an outright rejection of the registration.
Okay, so let's follow that thread. The land is registered solely in the Thai spouse's name. You've made this declaration that the funds were their personal funds. What does that actually mean for your legal claim to that piece of land? Even if, between yourselves, you contributed financially. Could you potentially lose everything related to that land in a future dispute?
When the property registration is done correctly, following this process with the joint declaration, then yes, legally speaking, the land is generally considered the Thai spouse's separate property. There's sin swan tua. This legally implies they have the right to sell it, mortgage it, transfer it, without needing your direct consent or signature. So in a purely legal sense, regarding the land itself, your financial contribution, if you made one without any additional legal safeguards in place, it essentially becomes treated as a gift to your spouse for the purpose of acquiring that land.
A gift? Wow.
However, and this is a big, however, this isn't always the complete picture, especially when we start talking about the structures built on that land, the house, the villa itself.
Ah.
Which brings us to a really fascinating and potentially helpful legal distinction.
Okay, that is fascinating because it sounds like it might offer a layer of protection, maybe one you wouldn't initially expect. The ownership of the land and the ownership of the buildings or structures on that land, they can actually be treated differently under Thai law. How does this separation work, and what are the practical implications for a foreign spouse?
This is genuinely a game changer for many people in this situation. It's a crucial point. While the land itself, as we've said, often must be registered solely in the Thai spouse's name due to foreign ownership restrictions, a house or another permanent structure built on that land, especially if it was funded using marital assets, sinsamroses, or very importantly, if the official building permit was issued in both spouses' names, that structure might be legally considered joint property.
Joint property, even if the land underneath isn't.
Potentially, yes. The crucial nugget here is understanding this concept. While the land itself might remain your Thai spouse's personal asset, sin swan tua, the physical building sitting on top of it can potentially be jointly owned, sin samros. This possibility of separate ownership of houses and land significantly affects management rights, selling rights, inheritance rights regarding the structure itself. It offers a really vital avenue for a foreign spouse to establish a clear legal stake in the physical property asset.
Okay, so if I'm the one contributing significantly to building a new house, or maybe doing a major renovation on land that's owned solely by my Thai spouse, how can I actively ensure that the house itself is recognized legally as being jointly owned? What steps can I take beyond just hoping or assuming it will be?
Right, you need to be proactive. The single most effective way is usually to ensure the official building permit for the new house, or for the major renovation, is applied for and issued in both your name and your Thai spouse's name.
The building permit, okay.
That document serves as very strong evidence later on, should it ever be needed, of joint ownership of the structure, even if the land title deed remains solely in your spouse's name. Other strong pieces of evidence, again, meticulous documentation of your specific financial contributions towards the construction itself, bank transfers clearly marked for building supplies, receipts for materials paid directly from your account, contracts with builders naming both of you. It's not just about chipping in, it's about being able to prove that your contribution was intended for and resulted in joint ownership of the actual building.
That makes sense. So if you're looking at that beautiful modern villa for sale in Phuket, or maybe you're planning a custom build project, knowing that the building itself and the land it sits on can potentially be separated legally, well, that feels like a fundamental piece of knowledge for protecting your interests and just feeling more secure in your investment, doesn't it?
Absolutely. It empowers you to ask the right questions and set things up correctly from the start.
Okay, speaking of securing an investment, we've talked a lot about traditional land and house ownership. But what about condominiums? Condos are incredibly popular, especially with foreigners, in places like Phuket and Bangkok and elsewhere in Thailand. How does ownership work for those? Are the rules different?
Yes, condominiums operate under a distinctly different legal framework in Thailand, the Condominium Act. And it actually offers a more direct route to ownership for foreigners. But, as always, it comes with its own specific set of rules and potential pitfalls. The primary rule you need to know about is the foreign ownership quota.
The quota, right.
Under Thai law, foreigners, collectively, cannot own more than 49% of the total floor area of all the units combined in any single condominium development.
49%. Oh.
Which means, practically, if 49% or more of the condo units in a building are already registered in foreign names, you as a foreigner simply cannot buy another unit in that building in your own name. The quota is full.
So what happens then if that quota is met, maybe in a really desirable building, and a foreign spouse really wants a specific unit there.
Yeah.
Is there a workaround? Can they register it in the Thai spouse's name instead? And what are the risks if they do that?
Yes, that is a common scenario. To bypass the foreign ownership quota and have the unit registered as Thai-owned, a joint declaration is needed again. Very similar to the land purchase process. Both spouses go to the land department, and the foreign spouse declares that the funds used to purchase the condominium unit came solely from the Thai spouse's personal assets, their sin swan tua.
Okay, same declaration process.
And this is a really important warning highlighted on our source material, providing false information regarding the source of funds for a condominium purchase. That can lead to serious legal trouble. We're talking potentially criminal charges for providing false declarations to government officials. It's absolutely vital to be entirely upfront and accurate about where the money came from. Trying to skirt the quota this way is extremely risky and definitely ill-advised. Don't do it.
That is a critical warning. Good to know. So beyond checking the quota and being honest about fund declarations, what other key due diligence steps should a foreign buyer or a couple take when they're considering a condominium purchase in Thailand?
Oh, several things. Absolutely verify the condominium's legal status. Make sure the development itself is properly licensed and built according to regulations. Check for any outstanding debts or encumbrances against the specific unit you're interested in, or even against the common property of the development. And, importantly, your lawyer should independently verify that the foreign ownership quota has not been exceeded before you sign any contracts or hand over any significant deposit money.
Don't just take the seller's word for it.
Exactly. Don't just take the agent's or seller's word for it. You need independent legal verification of the quota status for that specific building.
Makes sense. Okay, so given all these complexities we've walked through, from the land declarations, the separate building ownership possibilities, the condo quotas, how can you, as the foreign spouse in this marriage, really protect your interests effectively in the long run? What are the practical strategies?
Well, proactive measures are absolutely paramount. You can't just assume things will work out. Firstly, as we just touched upon regarding houses, actively securing joint or even sole ownership of the buildings themselves is a very tangible strategy. Remember, the strict foreign ownership restrictions primarily apply to land, not usually to the structures built on the land. So ensuring that building permit is in both names, or potentially even solely in your name, if feasible and structured correctly legally, secures you a direct, undeniable interest in the physical property asset itself, separate from the land ownership issue.
Right, focus on the building. And what about these specific legal instruments our source mentions, things like of Usufruct or superficies? How do they actually add a layer of security, and or what's the difference between them?
Yes, Usufruct and superficies. These are incredibly powerful legal tools available in Thailand, specifically designed for situations like this. A usufruct essentially grants you the legal right to use, occupy, and enjoy someone else's property. You can live in it, you can rent it out and collect the income, basically derive the benefits from it. It's usually granted for the lifetime of the person receiving the right, the usufructuary, or sometimes for a fixed period up to 30 years, which can be renewed.
So you don't own it, but you have the right to use it fully.
Precisely. You could, for example, register a usufruct over the land and house owned by your Thai spouse. This gives you the legal right to live there and benefit from it, even if they own the title. A superficies, on the other hand, is slightly different. It grants you the specific right to own buildings, structures, or plantations on land that belongs to someone else.
Ah, so that's how you could own the house on their land.
Exactly. This is perfect if you are funding the construction of your own house on land titled to your Thai spouse. Registering a superficies ensures you legally own the building itself, separate from the land title. Both the usufruct and the superficies must be formally registered on the property's title deed at the land department. This registration makes them legally binding, even against future owners of the land. It means your Thai spouse cannot just unilaterally cancel these rights without a court order or your agreement. They offer substantial, long-term security.
So choosing the right one depends on the goal.
Right. The strategic nugget here is choosing the right instrument for your needs. Usufruct is generally for broad usage and benefit rights, while superficies is for direct ownership of the structure itself.
Okay, those sound like really solid protections. Beyond these formal legal instruments, how important is just keeping good financial records? Bank statements, receipts, maybe even written agreements between spouses. Does that stuff really hold up in Thai courts if there's a dispute?
It is absolutely crucial. I cannot overstate the importance of documenting payments and agreements. This means keeping meticulous, organized records of everything. Bank statements showing transfers, receipts for major purchases or construction costs, copies of any written agreements you make with your spouse regarding the property, no matter how informal they might seem at the time. If you've contributed significantly to the purchase price, or paid for renovations, or even bought substantial furniture for the property, you need proof, clear proof. This documentation becomes your primary evidence if, heaven forbid, disputes arise later, perhaps in a divorce situation, or even in an inheritance scenario after one spouse passes away. As our source very wisely puts it, it's always better to have it and not need it than to need it and not have it. Thai courts do take financial trails very seriously when they are trying to unravel who contributed what and determine equitable shares.
Have it and not need it. Good advice.
Oh.
Okay, so let's say you've put some of these safeguards in place, maybe a usufruct, great records. How does that translate to the day-to-day management of the property while the marriage is ongoing and hopefully happy?
Generally, the rule is that each spouse maintains sole management rights over their own sinsuantua, their personal property. You can pretty much do with it as you wish, sell it, manage it, etc. However, when it comes to significant transactions involving sinsamros, the marital property things are different. For major decisions like selling or mortgaging immovable property, like a jointly owned house or condo, or maybe granting a long lease for more than 3 years, typically both spouses need to provide their joint consent. It's designed to be a joint decision-making process for major marital assets acquired during the marriage.
Right. And our source also briefly touches on prenuptial agreements. What's their role in all of this? Can they actually override some of these default Thai property rules we've been discussing?
Yes, prenuptial agreements are recognized under Thai law, provided they meet certain legal requirements like being made in writing, signed before the marriage, and registered properly. And they can be incredibly powerful tools. Essentially, a prenup allows spouses to agree before getting married on different terms for how their assets will be treated, both personal and marital, and how management rights will work.
So you can customize the rules.
To a large extent, yes.
Mm-hmm.
For example, you could stipulate in a prenup that certain types of income earned during the marriage will remain personal property, sinsuantua, rather than becoming marital property, sinsomrosis. Now, it's important to note that agreements made after the marriage, postnuptial agreements, that attempt to fundamentally change the statutory property regime are often more vulnerable to being challenged later under that Section 1469 we talked about. So getting things clearly defined and agreed upon before the marriage through a well-drafted, legally sound prenuptial agreement is usually the most sensible and secure approach to avoid potential future disagreements and ensure your financial arrangements are legally binding.
Sensible planning. Okay, now for the scenarios nobody really wants to think about, but we have to cover them. What happens if the marriage sadly ends, either through divorce or if one spouse passes away? How is the property divided or handled in those situations?
Okay, let's look at divorce and property division first. In a divorce, the Thai courts will primarily focus on dividing the sinsamros, the marital property acquired jointly during the marriage. Now, even if land is registered solely in your Thai spouse's name, remember we said it's possible to challenge that registration during divorce proceedings. If you, the foreign spouse, can provide concrete proof, remember that documentation, that your own personal funds, sinsuantua, were used to purchase that land, and you can convince the court that the intention was for it to be a joint acquisition or that you have some form of equitable interest. You might be able to claim a share.
So the documentation is key again.
Absolutely priceless in a divorce context.
Mm-hmm.
Also, there's a critical deadline to be aware of. If a foreign spouse is awarded ownership of land by a court as part of a divorce settlement, because foreigners generally can't own land, they typically have only 1 year to dispose of it.
Dispose of it meaning sell it.
Yes, they must sell it or transfer it to a Thai national within that 1 year time frame.
Okay. And what about the other scenario? Inheritance. If the Thai spouse passes away and maybe there isn't a will, does the foreign spouse automatically inherit their share of the property, especially if it was solely in the Thai spouse's name?
Not necessarily automatically, or maybe not in the way you might assume. This falls under inheritance considerations. If a Thai spouse dies without a valid will, intestate, then Thai inheritance law applies automatically. This law dictates how the deceased person's assets, including property solely registered in their name, will be distributed among their legal heirs. Now, the surviving spouse is a legal heir under Thai law, but so are other relatives, typically children and sometimes even parents, depending on who survives. They inherit according to a specific legal hierarchy and shares.
So you might end up co-owning with in-laws.
It's possible, yes. Which brings us to the critical importance of having a last will and testament. A properly drafted and valid will made by your Thai spouse allows them to specify exactly how they want their assets distributed upon their death. It bypasses those default statutory inheritance rules. A will ensures their wishes are followed, can protect the surviving foreign spouse's position, and helps prevent potential, often messy, disputes among family members over the inheritance. Furthermore, having those registered rights we talked about earlier, like a usufruct or superficies, or having clear documentation of your financial contributions, can significantly strengthen the foreign spouse's claims and position in inheritance matters, whether there's a will or not.
A will seems absolutely essential then. Okay, so listening to all of this, what does it really mean for you, the listener, contemplating this? It seems abundantly clear that buying property in Thailand when you're married to a Thai national, well, it isn't a simple DIY project you should tackle lightly.
Absolutely not. And this really raises the crucial question. Why is consulting an experienced Thai attorney, someone who specializes in property law, so absolutely critical? Especially given all the complexities and potential pitfalls we've just navigated through. Because, honestly, the nuances we've discussed today, they're really just the tip of the iceberg. And making a mistake, misinterpreting a rule, or missing a crucial step, it could be incredibly costly financially and emotionally.
So what are the key tangible benefits someone gets by bringing in that professional legal guidance right from the beginning?
Okay, well, an experienced attorney, first off, will explain these complex legal concepts: sin samros, sin swantua, usufruct, superficies, not just in theory, but specifically within the context of your unique situation and your goals. They will expertly guide you through those sometimes confusing registration processes at the land department, whether it's for land being registered solely in your spouse's name, or navigating how to secure joint ownership of a building, or handling condo purchases correctly. Crucially, they help you fully understand all the potential pitfalls before they happen, things like the implications of your Thai spouse having sole legal control over the land, or the risk of informal agreements made during marriage being overturned later on, or knowing your rights in a potential divorce. They are absolutely indispensable in helping you put robust, legally sound safeguards in place, like properly drafting and registering those usufruct or superficies rights we discussed. They ensure your property ownership goals are met safely, legally, and most importantly, with your interests properly protected. And finally, they will constantly stress and advise on meticulously documenting everything, every payment, every agreement, considering pre- or post-nuptial agreements, making sure you have the clear, undeniable legal trail if you ever need it.
It really sounds like it's an investment, doesn't it? An investment in your peace of mind and the security of your assets down the road.
It truly is.
Exactly. It's an investment in protecting your future, protecting your assets. Definitely don't leave something this significant to chance, especially when you consider the kind of value involved in luxury residential real estate, like the properties Ocean Worldwide deals with in Phuket.
Mm-hmm. And if we try to connect all these different threads back to the bigger picture, it's abundantly clear that buying property in Thailand when you're married to a Thai national, it's a sophisticated process. It's layered. While the land itself often, by necessity, resides legally with the Thai spouse, the crucial takeaway is that the building on that land can often be handled distinctly. And that proactive legal steps, coupled with absolutely meticulous documentation, those are your best friends in navigating this unique legal landscape successfully.
We really hope this deep dive has given you a valuable shortcut to being well-informed, arming you with the crucial knowledge you need to navigate this exciting but, yeah, pretty complex world of Thai property ownership. So the next time you find yourself envisioning owning that piece of paradise in Phuket, maybe pause and consider this. In a world just overflowing with information, how much of true ownership is fundamentally about holding the title deed, and how much is actually about understanding the intricate, sometimes surprising, web of laws and legal strategies that truly define and protect your rights and your investment. Something to mull over. Thank you so much for joining us on this deep dive.